Hi everyone, this is Advanced Pretrial, Mastering Refutation and Judge Questions. So first we'll begin with the questions. Pretrial structure from the intro to pretrial presentation, if you remember, is generally the basic fact summary from both sides, which is where questions come into play, and then the second half is rebuttals, which is what Videsh is going to cover. So first of all, answering questions. Usually judges will almost always interrupt you to ask questions. There are generally three types of questions. Those for clarification. If the judge doesn't understand your argument fully, they'll ask something that you can easily clarify. The second type is to poke holes in your argument and to see how familiar you are with your case. And finally, judges want to gauge how familiar you are with your evidence and how much you understand it. So in that case, we'll practice all these types of questions during meetings throughout the year. So that's not something too important to focus on. So to generally answer questions, there are two main steps. The first is to understand what the question is asking for. Evidence, could it be about the reasoning? Are they asking to explain something further? Just identify that. And secondly, you formulate your answer while being concise, polite, and persuasive. So for example, be direct without meandering too much. Number two, if the judge doesn't understand something, don't be like, you don't understand to their face. Instead, you should put it politely and say, our argument is something else. And finally, be persuasive. You should speak slowly, enunciate your language so that everyone can understand all of that. So general tips for answering questions. Number one, you should let the judge finish. You should never interrupt them because that just disrespects their position. Secondly, if you don't understand what the judge is asking, it's all right to ask for clarification once or twice, but it shouldn't become excessive. Otherwise, it just seems like you're stalling and you need more time, which of course reflects in the pretrial person's speaker points. And third, remember to invoke the overarching story that we're trying to tell. One way to do this is through putting emphasis on buzzwords as a way to tie everything in together. And then fourth, you should number your responses. So for example, if the judge asks you a two-part question, or you have two answers to a question, you should just organize it as cleanly as possible to avoid any confusion with your answer. And some things you should never do in any round. Never concede with your opponent's arguments because that is very difficult to come back from in the future. Never end with extra time still remaining after you finish reading everything, because even if you have a few extra seconds remaining, you can use that to your advantage. For example, by re-summarizing all of your points as a nice wrap-up to your case. Just don't waste that time. And finally, if you don't know how to answer a question, instead of outright saying that, always remember that evasion is your friend. While tax evasion might not be the best idea, using evasion tactics is great if you don't have any other answer. You can use this by using buzzwords related to the question in your answer, so it seems like you're answering the question even when you're clearly not. Or you can give a rushed explanation and then say you'll come back to it in rebuttal. However, we do not encourage this at all. If you continue doing this, the judge will start noticing it. Don't rely on this tactic. And just so that you understand that, here's a brief clip from the 2019 mock trial topic. It's about social media and a criminal threat case.
Section 422. To bring that count to trial, they must show probable cause or that a reasonable person would have an honest and strong suspicion that Sawyer Smith was in actual and reasonable sustained fear, that my client intended for this to be taken as a threat, and that this statement was so specific, immediate, unequivocal, and unconditional as convey the immediate prospect it would be carried out.
Well, let's talk about that immediacy, because there have been cases that have found that statements very similar to the ones that your client is accused to have made, that those have been found to be threats because of the context in which the statements are made, to include a history of animosity between the parties, which, to my understanding, has existed for at least 2 months with regard to some social media bullying and communication. So wouldn't that place your client's statements exactly within what courts have found to be a threat?
No, Your Honor. The surrounding circumstances we have in today's case don't meet the level of any other history of animosity in our closed library, and the subsequent action of unlawful violence is not directly related to my client.
Well, you may proceed.
Okay, so a few things to note. Number one, that was a very long and drawn-out question, which means he had to take some time while the judge is speaking to figure out what she actually meant, which is why it's so important for you to do that. Number two, notice he didn't have any time to prepare for the answer. He just thought about his own arguments and what the judge was asking while she was speaking. And Yeah, that's basically it. So just be prepared for when this happens because you might not have time to actually do it out there. One thing this person could have done better is number the responses. They actually had 2 responses, but you might have missed that if they didn't clearly say that they had 2 responses.
So for the next portion of this presentation, we're going to be going over the rebuttal portion of pretrial. So the rebuttal comes in the second half of pretrial after both sides have read their case. And it's basically going to be a speech in which you respond to the opposing team's case and just point out flaws in it, overall showing why your case is more strong. And during it, you see that the defense the defense always goes first, because as in the cases, the defense goes first. So in the rebuttal, the defense also delivers their rebuttal first. The rebuttal is going to be delivered by the same attorney that previously introduced the case. So on either side, there's just one attorney for pretrial. And for the timings, it's 2 minutes for both the defense and the prosecution. So you should make sure that you're only sticking to the best responses. Also, oftentimes many people incorporate evidence into the rebuttal. They either use evidence that they previously had in their case, or you can also add new evidence from the case law. Next, we're going to be going over some elements of the rebuttal. There are 3 main things that we think you should focus on when trying to construct your rebuttal. The first point is about introducing your evidence. When you add in new evidence, it can help to bolster your responses and show how your responses are more credible than your opponent's arguments. We also tell you that it's important to prove how your evidence takes theirs into account, because oftentimes they're going to introduce this evidence and this holding of a case. But if you prove that your holding takes precedent over theirs, it's going to be really easy for the judge to see how your argument is more important. You should also take a look at the judge's questions and utilize the questions that the other side has evaded to your advantage. Oftentimes, when the judge introduces questions that are hard for the opponents to respond to, they try to evade it. They don't actually adequately respond to it. So that's going to be in the back of the judge's mind. If you point out that same question and the same flaw in your opponent's case, then it's going to be really good for you. The final point is to focus on some responses and clarification. You should make sure to point out flaws in your opponent's argument and actually clarify the events of the case. So most importantly, you should prove why the events of the case don't actually fall under the holding of their evidence, because that means that their evidence doesn't apply and their entire argument falls apart. Next, we have 3 different ways that you can prepare for your rebuttal. So in the round itself, you should make sure that you're always taking notes. Jot down your opponent's case, and at the same time, you can jot down some responses that pop into your mind. So that way, you're not just going to be having everything in your mind when you give the rebuttal, rather you'll have it on a piece of paper. We would also tell you that outside of the round itself, you can prepare by having a responses document. What we did a lot this year was prepared pre-written responses to common arguments. That means that if your opponents just deliver an argument that you've already heard of, you have all these responses ready to go and a better understanding of how to deal with the argument. Finally, we think you should review. So make sure that you have a deep understanding of the case law and you take a look at every single case. That way, if your opponents introduce a certain piece of evidence, it's easy for you to actually take a look at it and prove how they're misusing it and how it doesn't actually work in terms of their argument. Next, we have just a couple tips you can use for your rebuttal. The first point is to always keep a conversational pace. You shouldn't go too fast in your rebuttal speech, and you should enunciate certain responses. That'll make it easy to follow along, and it'll also boost your speaker points. But second, we would say that you should be clear in which point you are responding to and clearly structure your speech. That means that if your opponents are giving 3 main arguments, you should first go along their first argument, then their second, and finally their third. That way, it's much easier for the judge to follow along. At the end of your speech, you should make sure that you're ending on a strong note and reiterate your request to the judge. For example, you can say that clearly, based on the arguments presented, you should vote on the defense's plea rather than the prosecution's. That way, it makes sure that you're not just abruptly ending the speech. The judge knows exactly what to do. Finally, you should deliver multiple responses for each argument. Like UV was kind of saying in questioning, you should give 2 different reasons as to why your argument still stands. In the rebuttal itself, you should also give multiple layered responses to your opponent's argument. That way, it just points out more holes in their case. Finally, throughout the speech, try to bolster your narrative. What that means is you can reference previous points you made in your case itself, and also prove how your evidence takes theirs into account. Overall, just construct this clear narrative that makes your judge very confident when they vote in your favor. Next, we'll be going over an example of a rebuttal.
Thank you. And do we have a rebuttal?
Yes, Your Honor. Now, counsel mentioned in her principal argument both sustained fear and the language of the message. So I'd like to take a look at each of those. Now, counsel cited People v. Chandler to show how people can sometimes hide the fear. But, Your Honor, what fear is Ms. Smith hiding from the police? Calling the police was a standard used in cases such as People v. Allen and In re Ricky T to show sustained fear or a lack thereof. In fact, in the case of In re Ricky T, the fact that the victim never called the police was enough to show the court that the victim didn't have sustained fear. Now, also, Ms. Smith went home that night and watched movies. Now, counsel brought up the argument that this was staying in the place where Smith knew she'd be safe.
Going back to Ricky T, I think we may have mentioned this earlier, but that was a completely different set of circumstances, and that there had been no acrimonious relationship. There had been no falling out between parties. There had been no loss of livelihood, and so therefore the court found that, first of all, because the police weren't called, but also, importantly, because there was no specific threat, that this really was more of an emotional outburst, having been unintentionally hit. And similarly, well, I should say, isn't that much different from what we have here, where we do have a relationship that has gone very, very bad in a significant period of time for 2 months.
Well, Your Honor, we'd like to take into consideration that the fact that all these things happened and Sawyer Smith still never called the police shows an even more egregious lack of sustained fear.
But I think that your opposing counsel mentioned.
So in that example, you can see that at the beginning of the rebuttal itself, that he gave a structured overview of what the speech would cover and said that the opposing team had 2 main arguments and he would go over each of them. That just makes it much easier for the judge to follow along and understand what the rebuttal is going to cover. We also tell you that when he was actually responding to their first point, he pointed out how the case itself is much different than the events, or the case itself is much different than the evidence that they presented, and how it doesn't necessarily meet the holding or the definition of what their evidence is trying to prove. That makes it so the judge knows that their evidence and their argument falls apart since it doesn't adequately use evidence and the holding doesn't meet the events of the case. Finally, the judge asked a question to him. Oftentimes in rebuttals, you might see the judge questioning you. It just depends on the judge. So you should take that into account and make sure that you know the responses you're going to be making and you're very confident in them so you know how to respond to the judge.
Case.
Okay.
So that brings us to the end of this presentation. Thank you, and I hope you learned how to effectively respond to your opponent's rebuttals and answer questions. See you in the next video.
Bye.